We'll move on to the sign-up sheet, just for informative purposes and due to the time restraints that we're under, because there is another committee meeting at 2 o'clock after this one. We're going to request that you hold your comments to about 3 minutes. We would be very appreciative. So we can, we have a lot of people signed up, and I would also request that that you keep your comments different, not the same, and we would be very appreciative of that. So first, on the sign-up sheet, Ms. Catherine Bernard.
Thank you, Chairman Harper. I'll try to keep things to 3 minutes, but just to give you a little bit of background, my name is Catherine Bernard. I'm a criminal defense attorney. I practiced as a public defender full-time in Lawrence County, so I spent a lot of time with probation and parole. Full days where you do nothing but probation revocation hearings and do nothing but deal with people who are on probation and parole and bond. So this is an area that I know a great deal about and would be happy to reserve as much of my time as possible for questions. However, what I am very concerned about, and I don't say this lightly, but everything that you heard from the previous witness was not true. And that started at the very beginning, where he kept referring to the Agency of Community-Based Supervision, or the Department of Community-Based Services. Let's call this by its right name. This is the Department of Community Supervision that they are seeking to create in this state. That is what they are seeking to do, and the fact that they do not feel that they can be honest with you about what it is that they are seeking to create should cause you to call into question the remainder of the assertions that were made regarding the interest of efficiency and administration that will be served by this bill. So this does create two gigantic new agencies. The idea that they would be cost neutral is frankly laughable to anyone in the criminal justice system right now. At the very least, it creates two powerful new commissioner positions that have not previously existed, and specifically authorizes the bringing on of employees to structure these agencies. This is not closing down the state boards of pardons and parole. This is not closing down the Department of Corrections. Yes, they're taking away some of their funding, but it means that you're going to have new employees, new offices, new expenses associated with creating these two agencies. I'll try to move through some of the concerns that were brought up by the previous witness. Yes, we do want to become smart on crime, but the reason why Georgia's criminal justice system has become such a difficult place to be is because we are simply putting too many people on probation who do not deserve it. I made this point when I spoke to the committee in the House on HB310, so I would of course dispute the characterization that no one spoke against it at that time. It was at that time during that committee hearing when I observed the lack of critical analysis being presented by members of that committee to the speaker that I became concerned and began speaking to other people throughout the state to let them know they're trying to start a Department of Community Supervision, and they won't even call it by its right name when they're talking about it to the committee. It's a serious problem. So yes, we all want this smart type of supervision, but the question is who we are putting on this supervision in the first place. This is not just a matter of probation and parole, which yes, that has been tried before to spectacular failures during the Carter administration and the Barnes administration. There have been serious problems with corruption and financial incentives in combining these two powerful agencies. But this also brings in people who have not been convicted of any crime. So when you hear that they are not going to be knocking on anyone's door unless they're a convicted offender, let me be very clear, that is simply not true. This applies to people who are on pretrial release. It's line 479 of the bill that specifically refers to the Department of Community Supervision administering pretrial release programs for felonies. And I can tell you that this is a distressingly common situation in the criminal justice system. Individuals who have simply been accused of a crime are placed on bond conditions so restrictive that they actually resemble probation or parole. I have had clients tell me that they believe that they have already gone through probation after spending a year or 18 months. In fact, I invited one of my clients to come up and speak today. He was unable to because of work, but he has been wearing an electronic monitor at his own expense for 18 months. And this is not an uncommon situation. You're looking at individuals who are having to make the equivalent of a rent payment in order to make their electronic monitoring obligations. And these, again, are individuals who have not been convicted of a crime, have not pled guilty, but merely have been accused of a crime. So the fact is that this brings in a serious due process question when you're associating individuals who have not been convicted with individuals who have been convicted. I would further point out that this also brings in aspects of the Department of Juvenile Justice, which was brought up by the previous witness. I will tell you what I have been hearing from individuals in the criminal justice system, assistant district attorneys, probation officers, deputies, the people who are in the courtroom seeing this every day. They are terrified by this prospect. They are saying people who joined DJJ to become probation officers for juveniles, they didn't sign up to carry guns. They signed up to be social workers. Instead, under this regime that is being proposed by House Bill 310, they will now be forced into that same model of carrying guns, of being part of this large agency that is combined with probation and parole. It removes the individuality of Department of Juvenile Justice and the idea that juveniles need to be rehabilitated in a different manner than you would with adult offenders. So that squashing together is going to end up hurting children in a lot of very serious ways. Moving on to some of the other points that were brought up. The vast majority of this is unplugging and replugging. Again, I cannot be more clear that that is simply not true. This is the creation of two powerful new agencies and the complete recharacterization of the entire probation and parole system. That's why it requires 119 pages to go through the bill and make so many changes. Some of the changes that this would include for probation include that these individuals who are on probation would no longer have the right to see a superior court judge if they were accused of committing some sort of action that violated the terms of their probation. And in fact, that was even referred to by the previous witness when he said, you have a right to due process and to appear in front of a judge. Not if HB 310 passes, you won't. Instead, you will be before a DCS officer who is alleged to be impartial, but frankly, I find it difficult to believe that we are actually going to be able to have someone who is part of an agency that has executive, legislative, and judicial powers, that this person is somehow magically going to become impartial simply because they are designated as such by the administration. So these people would be losing their right to be heard before a judge. And again, I understand people are probably thinking, well, this is only happening to criminals. This is only happening to people on probation or parole. Let me emphasize, Georgia is one of the only states that considers traffic offenses to be misdemeanor criminal offenses where you can be placed on probation. Everyone in this room is one traffic ticket away from being under the supervision of the Department of Community Supervision. One unproven accusation in court away from having the full might of this agency brought down on you. So when the governor and his agents are telling you about, oh, this is something that's just administrative, we are looking to reduce recidivism, what we need to do is examine why our system has become so overburdened in the first place. And I can tell you from personal observation, it's because our law enforcement resources are being allocated completely improperly. We are not going after the violent offenders. I know we're running short on time, but as I don't think you have a lot of other witnesses before you today who have actually had experience with the probation and parole system. I would invite any questions that you might have on the subject. There will be some other folks who could speak to other issues on this bill.
Any questions from the committee? Senator Howard.
Thank you, Mr. Bernard. Good to see you.
See you, Senator.
Quick question for you. I'm looking on line 495, and originally you had mentioned, which set my antenna up, about someone who was charged with a felony, but not convicted of a felony. Do you fall into that? Would that be a voluntary assertion by that individual to go into this program versus the normal status quo, or are you seeing that as two different things?
No, it appears to be just like the misdemeanor probation reforms that are being stated as reforms, but are really just a codification of what is happening in practice. What is happening in practice when someone is accused of a felony, when they are placed on bond, they are placed on electronic monitoring, they are placed on a curfew, they are given drug tests at their own expense. It is an extremely restrictive state of affairs, and that is what I'm referring to with the pretrial release program. It is not voluntary. Well, in that there is a fiction of consent and the judge says, well, you can stay in jail or you can agree to this program. I suppose it's voluntary in that sense.
Fair enough. Thank you.
Senator Williams.
Okay, when you say stay in jail, that's because they cannot get released on bond? Because they haven't been convicted yet. So why are they in jail?
These are the conditions of the bail. That's what is associated, this electronic monitoring, these drug testing. If they do not agree to these conditions, which they actually get even more restrictive. Now, many judges are asking all family members of an individual on bond to sign a Fourth Amendment waiver so that officers can come into their home at any time.
That's in the bill?
That's not specifically in the bill. That's something that is being done by,
That's not in this bill.
no, that is not in this bill.
Also, when you talk about,
Actually, I apologize. Let me walk that back in a moment. That is not explicitly in this bill to have them sign Fourth Amendment waivers. HB 310 operates as a universal Fourth Amendment waiver for anyone under the jurisdiction of the Department of Community Supervision. So in effect, it would do the same thing without requiring them to sign that additional waiver.
that made no sense to me, but.
Much of the criminal justice system prompts the same response from people.
Whenever you mention, whenever you mention that the individuals under parole, they don't have the ability to go back to the judge, that they're confined within DCS, don't they have the right to appeal the verdict of DCS back to the judge that originally sentenced them to parole?
I would make one clarification. There is a distinction between parole and probation in this case. Currently, individuals on parole are already under this kind of administrative system where they don't have the right to go before a judge. Individuals on probation are not considered to be part of this system. However, if HB 310 becomes law, then what would happen is these individuals would be treated in the parole sense, but they would also, their first appeal would then be to another DCS officer. So you've actually got
What about
two
their
layers.
second appeal?
The appeal after that, I think that would end up going to a Superior Court judge eventually. But as someone, again, who has dealt with these probation revocation appeals, the standard of evidence for a probation revocation is already very low. It's only preponderance of the evidence. So one thing that we're seeing is people will, there will be some trumped up charge made against someone, but the person is too afraid of the consequences to go to trial, and they're given a good, it seems like a good probation officer. I don't have to I don't have to go to jail. So they take that offer thinking they'll just deal with probation. Then how the officer who may have targeted them in the first place can bring another charge against them, knowing that they don't even have the right to a jury trial to have that heard. It's just going to be before a judge with that lower standard of evidence. So we are really depriving individuals of their right to a jury trial and their basic rights of due process.
Thank you,
Mr. Chairman. Actually, you may want to help me later on. I've actually requested a study committee on decriminalizing minor traffic offenses. But
Excellent,
I do
thank
have a
you.
question for you right now. Even though you say it's a legal fiction, though, isn't it accurate that sometimes defense attorneys will be the ones to actually ask or request that their client is placed on various electronic monitoring, things of that nature, as a way to keep them out on bond?
Yes, and I would like to distinguish here because obviously you have individuals in the criminal justice system who do pose a threat to public safety and who it is legitimate to require that they wear some sort of monitoring device before they can be released. There are individuals who fall into that category. In my experience, that is not the majority of individuals in this case. I have found myself sort of bargaining with judges and prosecutors, please just let him out. He'll wear an electronic monitoring device. Please just let him out to see his baby and work so that his family can have food on the table and won't be forced into government dependency. So yes, sometimes defense attorneys do have to make that bargain. It does not mean, unfortunately, that it is a representation of justice and the way that the Public Safety Committee would want us to operate.
And if that bargain was not made, would it be accurate to say that most likely the judge would place them in confinement?
Yes, despite the ruling of the Georgia Supreme Court in Ayala versus State, bail has become an exception in a lot of cases, and this is actually, I believe, contrary to the 8th Amendment of the U.S. Constitution as well, where excessive bail shall not be required. We are finding it routine that even on drug cases where there is no victim, there is no violent act, there is no property violation, that individuals are being denied bond. I recently had a client spend 10 months in jail for cocaine charges that were then dismissed on the morning of trial, but he was denied bond for 10 months. His baby was born during that time.
Nothing further.
Senator Dugan.
Mr. Chairman, I know that we're going to have to make.
We are.
In a second. I know that we're put on, you're going to make some announcements here.
That's right.
When you come back, I want you to explain to me about why they're all on trumped up charges. That's the words you used a second ago.
I will be happy to.
And I want you to prove that to me.
Certainly.
Ladies and gentlemen of the committee, due to the time constraints and due to the fact that we have another committee coming in and due to the fact that I have a committee meeting at 2 o'clock and 3 o'clock, we're going to suspend till 4 p.m. And you do have, y'all both have a committee at 4? Yes, we do, but we got a lot of deals on Wednesday too. That is what we work for. This is a busy committee, busy committee.
We do need to
Y'all do? So you got transport and transportation.
My bill is in transportation.
415. I'll send them a text. We'll suspend till 4:15. One, two, three, four. We got 4 committee meetings. Hold on just a second. Just for the record, earlier I read off a wrong LC number on a bill, and we need to make it correct for the record on House Bill 375, which was the very first bill we took up. It would be LC HB 375- Foxtrot Alpha FA. So moved. Got a second? Got a second. All in favor? Good. All right. Done.